All right, thank you for the opportunity to speak, everyone. It's a pleasure to be here. And before we really jump into the materials, I wanted to give a little bit of an introduction about Hendrik and I. So before ImmiPartner, Hendrik and I were actually corporate immigration attorneys at a big immigration firm where we worked with hundreds of companies across a great spectrum, variables on size, funding, industry, experience. And what we really noticed was that some companies struggled with the immigration process and some really thrived and used immigration as a tool for not only attracting employees, but also to retain employees. So the difference really wasn't whether the company wanted to do that. Of course they do. It came down to experience and knowledge, and also just the openness to stay prepared before things got urgent. I mean, oftentimes with immigration, it's something needs to happen tomorrow, and now you're backtracking and fixing things. So the companies that foresaw the issues were the really successful ones. So with that in mind, we wanted to go over some of the immigration trends that are currently affecting the work landscape today. We wanted to go over why you should care about immigration. So obviously the fact that everyone is here shows that immigration is important. But we want to make the case that immigration should really become a key aspect of your retention strategy for your employees. We'll talk about the shutdown, which, as we know, is the longest in American history, the H1B and the RFE issue that everyone, I'm sure, is seeing, and visa alternatives to the H1B. Now that denial rates have gone up, although not significantly, they're definitely increasing. People are looking to other alternatives to the H1B. So we'll be going over the most prevalent options and which employees these alternatives might apply to. Then we'll cover what's on the horizon. So the administration, has mentioned a lot of different things, floated ideas about what they want to keep, what policies they're thinking about getting rid of, and we'll talk about what's likely to happen and just the general nitty-gritty of what you can expect this year and maybe next year. Lastly, we really want you guys to walk away with some solid to-do items that you can implement right now to get your immigration program to a better place. So we'll go over some of the basics that you should be doing and hopefully get you guys to a better place.
To really drive this point home, we thought some statistics might be a nice way to kick this off. So the first point there and the chart that you're looking at illustrates that 70% of the core working group of residents in the Silicon Valley who are engaged in computer and math-related occupations are foreign-born, are foreign nationals. So that's an incredible statistic. They include architectural and engineering together. But even looking at that, that's over 63% of the working, so individuals 25 to 44-year-olds who are residents of Santa Clara and San Mateo counties, 63% of them for engineering and architecture, and then over 70 for computer and math are foreign-born. So it's I think that speaks for itself. In terms of the second point, there was a study conducted by SHRM, which is a well-respected human resource management organization, and they found that on average, when a foreign national is involved, kind of the onboarding recruitment process tends to take, again, on average, about 6 times more than it would for another a candidate or employee. Now, when Ting and I see that figure, it's actually pretty exciting because it shouldn't be taking 6 times as long. I mean, that figure isn't just due to government processing times. It's also due to companies maybe not having thought through an immigration policy very well, not having a set job bank that they can refer to, not being prepared for current trends in RFEs and how they can add to their initial case filings. So it encompasses more than just what's going on in terms of processing times with the government. So that we get really excited when we see that because you can really get a leg up on other companies from a recruitment standpoint if you dedicate some resources to really building out your immigration program and policy, and we'll talk about that a little later. The next statistic here is that immigration is important from just from a talent perspective, trying to recruit talent. So in a study that was conducted, 70% of foreign nationals, or those who need visas to get employment authorization, state that a company's green card policy, particularly in terms of when they're willing to start sponsorship for a green card, plays a major role in deciding whether they're going to join. That makes sense, but I think oftentimes we have seen companies that don't quite get just how important that is. And there's a lot of policies related to what kinds of visas a company is willing to sponsor, when you're willing to start those, who pays what fees, and we'll get into that a little later as well. But it really does play a key role in talent when you're dealing with foreign national, and there's a lot of foreign national talent out there that you're going to come across. The last item here is compliance. Under the Trump administration. So Trump administration, has stated and harped on the fact that they are going to, scrutinize companies' filings. They're going to, engage in more compliance actions than ever before, and they've certainly backed that up. So I have a couple of stats here. In fiscal year 2018, there were about 6,800 worksite investigations compared to 1,600 the year before that. Similarly, there were about 6,000 I-9 audits compared to 1,300 in the fiscal year before. So there really is a huge uptick. So we just want to start off with that. Everybody knows immigration is important, but even some of these figures were pretty striking to us when we were collecting the information.
All right, and now we're getting into the current trends. So the shutdown, with a lot of the other things we'll talk about today, there's good news and there's bad news with the shutdown. The good news is that 75% of the agencies and programs that deal with immigration remain open. And that's because USCIS and Department of State, these are agencies that run on the fees that they collect from the application. So they are not appropriated fees by the federal government. So your cases that are filed or your H1Bs that are processing, they're still going to be processing. There's no pause on the RFE. You're not going to miss a deadline based on that. So that's the good news. The bad news is that some new cases may be delayed. So that includes E-Verify, programs like E-Verify, and also the Department of Labor. Those agencies do receive funding, and they are currently shuttered. So with the E-Verify program in particular, and I know a lot of tech companies are enrolled in E-Verify so that they can hire STEM OPT talent. In prior shutdowns, they've issued post-shutdown guidance to address any of the lapses that the companies might have experienced during the shutdown. So any non-compliance that's happening because you can't get a new case started will generally be forgiven. And we do expect that to happen again once the government reopens. So the good takeaway here is that you should be monitoring the E-Verify website and talking with your immigration lawyers to make sure that you are doing what they're recommending after the government reopens. Right now, you're not required to open a new case because you can't, but you should still be doing the I-9 procedure on paper that you've always done. So with the Department of Labor, as you know, we filed PERMs and LCAs with them. They're also closed, so that's a little bit more tricky. So, I would say for the cases that are delayed with USCIS, where, you need to file the LCA to get the H1B or the E3 kicked off, in years past, they've accepted cases if the delay was caused by the shutdown, if you can show that the delay was caused by the shutdown. So, for example, if you have an H1B extension and the only reason you weren't able to file it in time is because the government was shut down and you couldn't file your LCA in time, document that, and you can use that as evidence of why that extension wasn't filed in a timely manner. With PERM, obviously, this is a little bit more difficult, but generally people are starting PERM, way in advance of their H1B expiration. So we do find that that's less of an issue. People are starting the PERM process, with 2 or 3 years left on their H1B. So the shutdown, lasting a few weeks, usually don't impact. It doesn't impact them quite as much. But right now, there's nothing we can do except to monitor these government agencies closely and just see if they have any guidance about the shutdown cases afterwards.
When we talk about LCA and PERM, so perm is related to, it's the first step in a particular green card process. So just to make sure everybody's on the same page there. And the LCA is a labor condition application, which is one of the initial steps that you have to go through before you can file an H1B type application. So that's why not being able to get that LCA certified right now is such an issue. And as Ting mentioned, if you can, after the shutdown, if you can prove that you didn't file an application only due to the shutdown, then they have in the past, accepted that and considered those cases. And then with E-Verify again, make sure you do the I-9. Just document that you can't do E-Verify, when you tried to do it, and then there should be some guidance that comes out after the shutdown, like they've done the past couple of times.
Okay, so with that in mind, we're going to jump into the H1Bs, which everyone probably deals with. The H1B RFE issue is something that's become very, very prominent over the last year, and it really started in April 2017 with the announcement of President Trump's Buy American, Hire American executive order. So this chart is particularly telling of how this impacted H1B. So if you'll take a look at the figure in Q3 of 2017, and this is a chart on the percentage of RFE issuance for H1B cases by USCIS. In Q3, for all the H1Bs that were filed, 22.5% received RFEs. It's a little bit higher than the Q2 and the Q1 figures of 13.5 and 17.3% respectively, but it's still within the realm of reason. Fast forward to Q4 when everything kind of started happening. That number jumped to 68.9% for all H1Bs filed. And that figure is even more remarkable for Indian nationals, which is just on the row below that number. It's 72.4%, which means, for anyone that you're filing an H1B, where there's a, 2 in 3 chance that their application will get an RFE. So it's not a matter of if you'll receive an RFE, it's when you'll receive an RFE, if it's really part of your visa repertoire for your employees. So obviously H1Bs, what's a big fuss? Why does everyone want H1Bs? Why can't we just use a different visa? And the reason is really threefold. The first reason is that H1B is one of the only visa types where an employee can have dual intent, meaning they can be anywhere on the green card process and still have an H1B. So everyone wants to be on the H1B so that they can start the green card process. This is contrasted with a visa type like the F1 student visa. It's a typical non-immigrant visa where you're supposed to maintain this intent that you don't have the intention of immigrating to the United States. H1B, even though it's technically a non-immigrant visa, it's specified in legislative rules that it can be dual intent. So that's one of the key reasons why most people want H1Bs. Second reason is that the threshold is relatively low in general. You just need a bachelor's degree, and you need a job that requires a bachelor's degree. So you don't need to be at the top of your field. You don't need to, be this amazing. So students coming out of school can apply for the H1B, and that's why it's so attractive. And lastly, you can apply for the H1B for anyone. It's not a treaty-based visa, so you're not, it's not like a TN visa under NAFTA for Canadians or Mexicans. So no matter what country you're from, you can apply for the H1B visa. So for those three reasons, that's why we hear about H1Bs so much, and it is the most frequently used visa type in Silicon Valley for professional workers. So the good news with the H1B RFE issue is that USCIS isn't super creative. We see the same issues. We tend to see the same issues come up over and over again, and that gives us the opportunity to strategize and prepare in advance. So knowing that you will very likely get RFEs on certain issues will allow you to plan for that and make sure you're submitting a good application from the get-go, and also to prepare RFE materials when you do receive the dreaded RFE. RFE stands for Request for Evidence. It's a document that the government can issue after they do an initial review of your application. So it could be the first response you get from them. Generally, when you file, you don't get a decision right away. You can either get an approval, which is great, or you get an RFE. And it's your opportunity to address whatever concerns they have. Now, the one thing, one caveat with that is the USCIS has announced that they are looking to maybe issue denials without RFEs now. So another reason to be really, prepared with your initial application. So with that in mind, we're going to go over 6 major challenges that we see, or 6 RFE issues that we see frequently, so that at least you're prepared to think about them and address them at the beginning of an application. So we've separated them out into 3 categories. The first category deals with this idea of specialty occupation. I'm sure you guys have heard about specialty occupation if you've worked with H1Bs. A specialty occupation within the immigration context means it's a job that requires, at minimum, a bachelor's degree in a specific field. That's all it means. So the first challenge that we see is that USCIS is saying that your job duties for this H1B application, they're not detailed enough. We can't tell from the job description you submitted that this is a specialty occupation. So obviously, the solution would be craft a detailed job description. But the follow-up question is, what does a detailed job description look like for immigration context? So I'd like for everyone to turn to the H1B RFE reference guide, where we've actually provided a good job description versus a bad job description. Suffice to say, the job description that you post on LinkedIn or Monster is probably not good enough for immigration purposes. So it's a good idea to go back and actually take a good look at the job specs you're putting out there into the public sphere, because USCIS do Google companies and confirm whether what you're submitting matches with what you're putting out there to make sure that you're putting the right thing out there from the get-go. So some of the key things that you should be doing, we've kind of covered in paragraph 2 under the section about writing a detailed job description. So you want to make sure the duties are drafted in a fashion that's undeniably clear and definite, even to someone who isn't an engineer. So that means maybe spelling out what C++ is. It's a programming language, or expanding on the acronyms that everyone knows about, so that USCIS officers who aren't even immigration lawyers would understand. And that really helps us allude to the technical aspects of the position, which we see a lot in STEM roles. So looking at the good job description, you can see there's a couple of things done right, and we've tried to mark them up in red. For example, you want to write how it says software engineer too. So from the get-go, this is not an entry-level position, right? Like, you can use that title internally, and it's a good idea to kind of start differentiating from the very beginning. I know we're talking to a lot of earlier stage companies today, and you guys are in a really good position to make sure that you're doing things right from the very, very beginning, so that when you are ready to scale and scale rapidly, you already have a good backbone to kind of go on. The second good thing that this job description did was to note exactly the degrees that are required for this position. So it says BS or MS in computer science or electrical engineering. So we know it's a bachelor's degree. We know the specific majors. Oftentimes I see BS, and that's it. And they're definitely going to have issue with that. We need to specify the fields that you want these degrees to be in. And also make sure that you are actually recruiting people with these degrees. I mean, when you say that you require a bachelor's degree in computer science, but then you accept someone with a bachelor's degree in physics, it obviously shows that's not the requirement for the position. So make sure you list out what you'll actually take degrees from.
Just to piggyback on that, so one of the best arguments back in an RFE, if you're getting a challenge on specialty occupation is, if you can show, these are our requirements in the company. We have 15 people in this position. They all have this particular background and bachelor's degree, for example, that we're requesting. This is a real requirement that we have. And so that oftentimes, can really help. And this goes beyond just H1B into, when you start the green card application and you have to lay out the requirements as well. Consistency is really key. And I know that can be hard because you want to be flexible and make exceptions. But if you really, and we'll talk about job banks later and how this can help, but it's just also very helpful in terms of responding, because one way to prove specialty occupation is that it's an industry standard, or that your company has always had this requirement and it's an actual requirement.
So, we can take a quick look at the bad job description on page 2. As you can see, it's a lot less detailed, and it includes a sort of soft skill sets that we see in real life recruitment, such as strong communication skills. You probably want to take that out, for immigration applications, and maybe even revise it on the job duties you're putting out there, on your website, or at least specify that's like 0%, of time spent, or just like general skills, something like that. So that's something you can easily do. I know it's going to take time, and your managers are probably going to push back a little bit, but it's going to save you a lot of headache and a lot of time down the line. So the second USCIS challenge under the specialty occupation category is that deals with a DOL survey that states the job does not normally require a bachelor's degree. So we're going to get into this idea of SOC codes a little bit. So as Hendrik mentioned, an LCA is something you have to file before you file an H1B, and that's a labor condition application with the Department of Labor. As part of the LCA filing, you have to choose an SOC code to go with the position. So SOC stands for Standard Occupational Code, and it's this database that the Department of Labor puts out where they try to match a code to every job that's out there. But the problem is, this database was written a decade ago, probably, and really doesn't encompass everything that's out there. So what you're left with is a situation where for any given position you have, there's probably 3 or 4 SOC codes that are applicable, and you kind of have to choose which one's the best. So, it's not ideal, but that also gives us a little bit of wiggle room in picking the most optimal one. So what you want to do is actually look at the SOC code, look at the Department of Labor profile associated with that code, and you'll see actually they list out the percentage of employees in their survey that has a bachelor's degree. So for example, for a computer programmer, it could be like 50%. And I use that as an example of something that you shouldn't choose, because computer programs for that reason is actually an SOC code that is very targeted by USCIS. So if you file an application with a computer programmer code instead of a software engineer code, you're very much going to get an RFE, if not a denial. So that brings us to another point in terms of staying on top of these trends with which SOC codes do they like, which SOC codes are they scrutinizing. And your immigration attorneys are the best sources for that, because they're dealing with it day in and day out. And it does change from time to time. So just know which SOC codes that you're assigning to a particular position. That's one of the data points that should go into your job bank, so that it doesn't deviate. You shouldn't be jumping around, depending on the position or the person, but really understand that. So if you look at the reference guide, page 3 and page 4, how to determine the wage level. And part of that situation there talks about the SOC code too. So the next slide will jump into RFE issued in the wage level category, but this is a database where you can actually look up SOC codes by a natural language search. So follow the instructions on there. That should help you in determining that even before you work with an immigration lawyer.
And there's a lot of info in there, and it actually links to like a whole dictionary of positions, and it has job duties in there, usually like 20 different job duties for each position type. So it's really, really useful to get familiar with that, or make sure whoever you're working with is very familiar with that.
So the second main category of RFE issues that we see deals with this idea of a wage level. So again, if you've worked with H1Bs and LCAs, you know as part of the SOC selection, your attorney is going to ask you what level is a position. And sometimes they pick it for you based on the job duties, but really you should be driving the conversation based on a series of factors we'll discuss now. The first USCIS challenge we see in the wage level category is this idea that because an H1B position has a level 1 wage, it's not a specialty occupation, meaning any entry-level position is by default not a specialty occupation, which is really faulty logic because they're applying this to positions like for physicians, for lawyers, for senior engineers, where the basic minimum threshold for entry is probably grad school, beyond that bachelor's, but they're making this argument. So what you can do is, going back to the job description, even for an entry-level role where you have to select job level 1 because of the salary you're paying this person, be prepared to explain why most of the duties require a bachelor's degree. So if you go back and you have a good job description, even if it's software engineer 1, you can clearly show how 5 out of the 6 job duties require bachelor's degrees, and the bachelor's degree courses that we've listed. I mean, this is an easily fixable issue, just with a little bit of preparation in the very beginning. So, I've mentioned something about, wage levels. The guide that we have put together actually goes over in detail the DOL definitions of these 4 wage levels. So we get questions a lot, about what does that even mean? And, when you ask a manager, they'll just kind of throw an arbitrary number out at you, like wage level 2, that sounds good to me. What you should really be looking at are these definitions that we have on page 3. So what you should do is compare the job duties and see if it's an entry-level position where the employee is performing routine tasks that require limited, if any, exercise of judgment. If that's what it's looking like through the job duties, even if it says senior software engineer, you should probably be choosing a level 1 wage. They're really going to look at the substance of your job duties in making that determination. And that brings us to the USCIS challenge number 4, where the government can say your job description doesn't match the wage level selected. So you have a very senior role with very senior job duties, but because you're a startup and you're kind of paying people more in equity, you can only have a wage level 1 salary. So for that reason, you choose a level 1 wage. That's not an ideal situation, and please be aware that's probably going to cause issues. You might want to negotiate and maybe bring it down a little bit on the equity and bump up the salary just so that their job description actually matches the wage level of the position based on these DOL descriptions.
So we just have a couple more here we wanted to highlight, and these tend to come up for earlier stage companies. For challenge number 5, something that is very easily avoided that we want to stay on top of is just mismatches in data between what you provide on your H1B application, for example, to the government, and data that the government has on your company, essentially. So USCIS, they have a VIBE program, Validation Information for Business Enterprises. A very exciting name. And they outsource this data collection and maintenance task to Dun & Bradstreet, which is a rather large organization. So that's their information provider for this. So what they do is they'll get your immigration forms for an application, and they will do a check against this VIBE database, or the VIBE programs database. And if there are mismatches in what Dun & Bradstreet has on your company's location, on your industry classification, for example, it's very likely you're going to get an RFE on that. And when they send you an RFE on one item, they're probably going to just check off all their other template requests and print it out and mail it to you. So you're going to have to probably answer 2 or 3 issues on top of this, which maybe they would have just totally looked past or avoided because it's not really an issue they should be challenging, like wage level 1, for example. So in the handout I believe it's the last page, there's a little blurb there on this public-facing Dun & Bradstreet portal, which you can go into, and you can actually see the information that they have, that Dun & Bradstreet has on your company. And for free, you can go in and you can actually update that and make sure that that's actually correct, so that whatever you're submitting on these applications actually matches what they're going to see on their end. So It's a pretty easy fix. You can probably update this within 5 minutes. It's free to do. They try to make it confusing so you end up paying for this, but it's free for you to go in and access it. And if you follow the website link that we included in the guide, that should take you to like the free portal essentially. So that's the easy one to avoid, and that should, if there's any changes in location as well, or there's any significant changes with the company, make sure you update that, and somebody's assigned that task to do that. Challenge number 6, inability to pay the offered wages. So Ting talked a little bit about, wage level. There's 4 wage levels, and which wage level are you going to pick for the job? The spin on here is that the challenge is your company really able to pay this wage? And so we tend to see it for companies where the officer maybe doesn't recognize the name of your company, or it's, you're just a smaller company, and they can tell because you're telling them how many employees you have on board, and maybe you're pre-revenue, you don't put any revenue figures on the immigration form. So there's certain triggers for them where they might be more likely to ask about this. Well, I will note for H1Bs, there's actually no requirement for this in the H1B regulations that you have to prove your company can make this payment. It doesn't stop them from asking for this, and I think it's because in the green card context, there is a clear legal requirement that you prove your company has the ability to pay for this green card submission. So they've kind of conflated the two, and you can make that argument if you get an RFE on this, but best to just avoid the RFE altogether. And so to do that, if your company is pre-revenue or you don't have great revenue or income figures, is to be somewhat creative. So you can submit bank account statements. You can submit any media coverage about your company. You really want to establish the legitimacy of your company. If you can prove funding that you've obtained, the source of that funding also tends to make a difference. So you should really work to essentially maintain a packet of documents proving the legitimacy from a financial standpoint, and just the legitimacy of your operation, that it's not a fly-by-night operation that's being used for H1B applications. And you can obviously update that. You should update that pretty regularly, and you should submit that with every initial filing. So hopefully it just takes this issue off the table completely. Those are kind of the six of the challenges we see. There are more challenges, but we see several of these pretty repeatedly. So hopefully that guide will help. Some key takeaways, though. So we've mentioned a lot about job descriptions, wage levels, these occupational codes you're going to select. Really, one of the key things that I would say relatively few companies put enough time into, and it would really help. And I know companies don't do it because it's difficult to do, but is to try to create some sort of consistent job bank as early on as possible, or I know it's more difficult the further down the line you go, but to really try to keep immigration in mind when you are creating job descriptions, job titles, job levels, because ideally, whatever you put out there in the public for recruitment is actually what you're also submitting in your application, and Ting alluded to this. And that's pretty rarely the case, actually, and that causes some issues because the officers are wondering, is this company really just trying to do whatever they can to get this person to work there? And oftentimes, that is actually the case. That's not what the Immigration Service wants you to do, though. They have an argument in certain cases for that, so it's understandable on both sides. But really, the best thing you can do is to sit down look at your job descriptions, or if there's a new position you're going to be hiring for and you're creating a new one. Use the guide we provided. Really take time on the duties. What percentage of time is someone really spending on these duties? What are your actual requirements for this position? And try to take a look at those SOC codes. Work with your in-house immigration resource or your law firm, however your company might be handling this. Pick the 1 or 2 codes that really do make sense. You can update that, obviously, as things change. Kind of what's the salary range you want to pay, keeping in mind the salary ranges you have to pick for the prevailing wage that you submit on these cases. So you'd really be doing yourself a service by doing this from an immigration standpoint and an efficiency standpoint, reducing the number of RFEs, making sure you don't have to backtrack on something. And so this will reduce that initial figure I talked about. It takes 6 times as long to get through this process if there's a foreign national involved. This is one of the key ways where you can make a difference in just the overall efficiency of that whole process. So that's really key. In addition to that, obviously, there's a lot going on in immigration, a lot of trends to stay on top of, a lot of RFEs, strategies that can be used. So having a trusted immigration firm is absolutely important, and one that really matches with your company's needs in terms of bandwidth, expertise, industry, what kind of cases are you used to dealing with. If you place individuals at third-party sites, do they really know about the third-party placement issues that are going on? So that is key, and I think a lot of people do understand the importance of an immigration law firm. I do think that companies tend to put too much on the immigration law firm in terms of believing that this law firm is going to run our immigration program for us. That's not the case. That's not the way you should be thinking about it. They are there to efficiently turn around and process cases and use their expertise to do that. The companies that are in a better position, usually from an efficiency, workflow, kind of data tracking, budgeting, workforce planning position, there's obviously overlap with HR here, but is to really to dedicate resources internally to really build out those policies and see what makes sense for your company. The business model of a traditional immigration law firm doesn't really lend itself to giving you enough time on that policy and those procedures. And sometimes there are also conflicts of interest that occur because immigration law firms generally representing the company and the employee in these filings. And so there's a number of reasons why you should also have some strong in-house focus on this. So those are a couple of key takeaways because there's so much that you can really do internally to help the efficiency and increase the approval rates and decrease the RFE rates of your company.
One thing you should be aware of is that in terms of updating your information, not only should you do that, when you move, but you should also be evaluating if you need to file a H1B or other visa amendment every time you move offices. You don't want to be doing this retroactively because if you don't update with an amendment, the USCIS officer tasked with audits might show up at your old address and completely blow everything out of the water because that company, your company, is no longer there. So anytime there's changes to the employment details of your foreign national employee, you should really be asking the question, do we need to do anything on the immigration front? Because oftentimes the answer is yes, even if it's just updating the LCA. So moves, promotions, changes in title, as well as salary, these are all things that should be triggers in your mind, to ask the immigration questions. So given now that we know H1B is super, super challenging, the RFE rates are up, there are some denials here and there, it's helpful to know which alternatives might apply for which employees because you'll be getting these questions. And the ones that we've listed here really do cover the gamut of generally what's available for someone who matches well with an H1B. So it doesn't cover the alphabet soup of the visas, but these are your alternatives. And I would actually point you to the basic guide to visa options for foreign nationals employees handout that you have because we actually list out all the visa types that you'll see in the corporate immigration setting, and these are covered. So we'll go over them really quickly, but for more detail, take a look at this. Okay, so the first point, OPT, STEM OPT, we've talked about it briefly. These are for the new grads from a U.S. institution. So I know a lot of companies recruit from like Waterloo in Canada. Those new grads don't have OPT. It's only if they graduate from a U.S. institution. And OPT stands for Optional Practical Training, which means for any new grad with such a degree, they get up to 12 months of employment authorization with a given company, provided that the job is related to their actual degree. So you can't have someone with an art history major who's self-taught themselves, coding, and then now you're giving them a software engineer role. That won't work. And additionally, if that degree program is a STEM field that's recognized by ICE, then they get an additional 24 months. So altogether, for someone with a computer science degree graduating from a U.S. institution, they can get up to 3 years of work authorization on this. And our advice here is to maximize this time as much as possible. So do everything you need to do in terms of supporting their STEM OPT application. That means enrolling in E-Verify because you have to be enrolled in E-Verify to even use STEM STEM OPT as an option for your employee, and then also doing the 6-month evaluations on their STEM OPT plan. Just because you got the EAD card doesn't mean that you're done. Make sure you're submitting those evaluations, work with your employees to submit those evaluations to their school's DSO or designated school official. It's really not that much admin work, but it's going to give you the flexibility of not depending on the H1B the first time, because you'll get 3 chances to apply pretty much.
Okay, O1, alien of extraordinary ability. This is a great option for professionals who you might be considering for H1B, but actually who have a lot of proven expertise in a particular field. Usually kind of the more niche the field, the easier the applications tend to be, but it doesn't have to be that niche. But it's really somebody who can show that they have kind of separated themselves from kind of the norm in their field, whatever their particular position is. And there's various criteria you can use to prove that. So they've worked in lead roles on well-known projects with well-renowned companies. They have publications out there. They've spoken at conferences. They've judged on panel, all sorts of criteria. I think it depends which O you're talking about, but there's 6 or 7 criteria you can use, and then there's one that kind of allows you to just be creative. So you have to satisfy at least 3 of those criteria at minimum, and then you're potentially eligible for O1. Some of the benefits to the O1 and why you should consider it, even if you have an H1B option as well, because you have somebody that is very talented and experienced, is that there's no quota, right? So we just talked about this H1B quota issue. You can file these any time of the year. You don't have to worry about kind of the wage levels and the prevailing wage and all of that on O1s as well. I did want to note, let's say you do have 2 options. You're certainly allowed to proceed and attempt 2 different filings as well, or to be prepared to file one if you're having issues with the other. There's some complications on that. You just need, if both get approved, which one was approved last is generally the status the person's in. So you may or may not want to do that, but just know it's worthwhile considering more than one option, especially if you're looking at an H1B, especially a cap subject H1B. You want to have a backup, and we'll talk about some other backups now.
Now let's move on to treaty-based visas. So treaty-based visas are interesting in that, similarly, there is no cap, but you do have to be from a specific country. And it's based on which trade treaties the United States has with that country of origin. And we have a lot of trade treaties, but there's only 5 countries that you need to be aware of from the immigration setting, because those are the treaties that provide for a special visa. So the countries are Canada, Mexico, Australia, Singapore, and Chile. That's it. But anytime you have someone from those 5 countries and the H1B option isn't a good fit, or you're running into issues with it for whatever reason, you really should be asking yourself about these visa types, because generally people that qualify for H1B will qualify for these visas as well. As far as requirements and everything goes, I would refer you to the guide again. It's a nice 1-pager on requirements from the company, the employee, and also some details about costs of application and what their dependents, what their spouses and children will get in terms of immigration status.
J1 trainees and J1 interns. Wanted to put this on there because this comes up pretty often, or people are really trying to be creative and find anything that works. So I kind of wanted to address this. So really the thrust behind the J1 program is for trainee and interns is essentially to give foreign nationals the opportunity to get experience either related to their academic background or just their occupation outside the U.S., to bring them in, to give them experience up to 12 months for interns and 18 months for trainees, to have them come in, get some experience that they cannot otherwise get in their home country, with the idea that they're then going to take that skill set back and apply it in their home country. So that's really, I guess, the thrust behind the J1. That obviously doesn't match up very well if your intention is to use this maybe as a stopgap before applying for an H1B or switching to an O1. I'm not saying it's not possible. I'm just saying that you're going to have some challenges in a lot of cases. I have seen this happen successfully, make that transition. I've also seen a lot of problems, whether it's with the actual third-party J1 sponsoring agencies involved, and that really don't want the individual to change status and actually sign something saying they're not going to change, it just opens up the door to a lot of potential issues. But if you do have somebody and it would be useful for your company to have them on board for, let's say, 18 months, and they are going to get something out of this training program, because you have to prepare a training program for the trainees, and you're okay with them being there for 18 months or less, then it certainly is something to consider. There's various steps. It's not too challenging. So if that kind of time frame works out for you, then certainly consider it. But I just wanted to kind of throw that caveat in there because it comes up a lot and is sometimes not the best option to pursue.
Tangential to that, there's no extensions really. You can extend J1s for very, very specific reasons. Like there's a major issue with the sponsoring company in terms of HR conflicts, things like that. There's an explicit list, but generally 12 months and 18 months, that's all you get. And they will not usually approve extensions. Okay, so let's move on to the L1 intercompany transferee. So for those of you that have worked with bigger companies, you probably have heard L1s being thrown around. And that's really an option if you have a multinational presence. So there's 3 questions that you should really be asking yourself. And if you can say yes to all 3, then L1 will be on the table for your company. One is, does it have a foreign affiliate in the form of a parent company, sister company, subsidiary, or even an operational branch outside of the U.S. 2, is the person that you're trying to get the L1 for an executive, a manager, or a specialized knowledge employee. And by that I mean someone with knowledge about the company's processes, technology that you can't really get within the U.S. workforce here. 3, has that person worked for your foreign entity for 12 months out of the last 3 years. So not that they're just on their payroll, but are they physically outside of the U.S. working for that company? If you can say yes to all 3, then the L1 would be on the table for you. And that coincidentally, that's the only other visa with the dual intent thing that we discussed with the H1B. So it is a good option because it's good for green cards, but it only applies in very specific scenarios. And maybe with everything that's going on, that's a long-term strategy. If you're planning on expanding into a different market, perhaps it makes sense to create that company, transfer an employee there, keep them there for a year, and then get the L1 for them. I mean, we've seen this happen, for companies that have that plan anyway, so it's good to know about these visa options.
If you are setting up that foreign entity, you have to prove that that's an ongoing, legitimate entity, obviously, and that it for somebody to hold the L1, you have to maintain that relationship between the U.S. and the non-U.S. entities as affiliate, parent, subsidiary, whatever their relationship might be. Okay, so then the last point, moving employees outside the U.S. So let's say you're having trouble, your H1B cap case from filed last year still is not adjudicated, and somebody's run out of OPT time, and there's no options. By necessity, more companies are considering and actually following through on essentially placing employees in Vancouver, for example. The Canadian government in particular has really seized on what's going on here in the US, and they've made the process of getting a work visa in Canada very streamlined, a matter of weeks compared to for us. Again, it's over a year or about a year in cases still haven't been adjudicated. And there's actually companies out there that provide like a turnkey solution. So they take care of payroll, setting up any business documents that are needed in Canada. So people had always kind of thought about this idea before, but now people are actually having to follow through on it. Not a huge number of companies, but some people are doing it. And just by necessity, if you really want to hang on to that individual, obviously if they're willing to go there, and hopefully they don't like it too much and they're willing to come back if you have an option. What's on the horizon? There's no comprehensive immigration reform on the horizon, and probably won't be for a while. We're trying to deal with much simpler issues that we're having trouble dealing with. So let's take a look at what might actually occur this year or potentially next year. I did want to note that Trump did tweet that they were going to create a pathway to citizenship for H1B holders. Not quite sure what that means, because you'd have to go through a green card step first, but hopefully that's a good sign that there's actually some realization that there's a lot of value in the H1B program, but we'll see what happens with that. Let's start with premium processing, the big topic I'm sure everybody is well aware of. So The past 2 cap seasons, there have been premium processing suspensions. And so usually when premium processing is available, you'd have a decision by October 1st when then somebody can then start on H1B with your entity. As the example I gave earlier, there's still cap cases unadjudicated that were filed April of 2018, and there's nothing we can do about that. So it causes a lot of challenges in terms of being able to plan, obviously, and then what do you do with this talent that you really want to hang on to? It makes it very difficult. There was a expansion of the premium processing suspension to virtually every H1B case unless you are filing just a very straightforward extension with no changes in the individual's, no material changes in the individual's job duties or anything of that nature. And I will let you know, and the immigration law firms are on top of this, but there's one box that you can check that if your case falls into that category of just an extension based on a previously approved case with no change, then premium processing is still available. But everything else, transfers, there's no premium processing, and that's probably causing the most headache, I think, in trying to get somebody to commit to your company and start in the relatively near term. Because there's no premium processing, instead of it taking a couple of weeks before that happens, it could now take half a year. Or it depends on if you're getting an RFE or not. And is that individual willing to start working with your company before this case is approved? Because the individual is allowed to start working with your company before there's an approval. So once you get that transfer application on file with USCIS, and you should wait to get a receipt notice, and you could get that electronically if there was premium processing, but there isn't. Once you get that notice, then it was pretty standard for individuals to start working with the new company and wait and get their approval. Now people, just with everything going on, people are much more reluctant, and that's understandable why. Not just reluctant, but you might be looking at a 6-month timeline. So it can be very challenging, and I'm sure many of you have experienced that. So that's what's happening now. That current suspension is set to end February 19th. Are they going to extend that further? It wouldn't be surprising. I really hope not. I think it's pretty safe to say for actual cap, based on what they've done the last 2 years, it's probably likely there's going to be some suspension of that, whether it's before or they announce it right after cap season kicks off. We'll see. But that's probably the most likely in the short term out of these to occur and have a major impact. So any H1B filing, essentially, except a very simple extension, plan for there to be delays and issues, consider the alternatives, and have that discussion with your foreign national employee. They're probably going to be well aware of these issues, but it's obviously good to just be open and talk about that. So upcoming potential changes to the H1B, there was a proposed rule change released, and then it has to go through a notice and comment period. That notice and comment period just ended, and really the main thrust of that proposed rule change relates to pre-registration for H1B cap, and then the way that they actually allocate essentially the slots that are available for cap, which we discussed earlier. So for pre-registration, the idea is that essentially this lottery would happen before you file your case, as opposed to how it is now after everyone files their case. So some of the proposed requirements, which could still change because it's not a final rule, is that the company would have to let the government know at least 14 days before April 1st, before that cap season opens up, the number of cases they plan to file, and provide some background about the company and about the individual foreign national who's kind of the target of this application, some of their basic background. They say it's a relatively short form, we'll see, of information that needs to be provided. Then the government does their lottery, and then they let you know for these 5 out of 10 applications you let us know you're thinking of filing, you have a spot for those 5. You can go ahead and file the cases, and then it's proposed that they would give a 60-day window within which to file those cases. So it wouldn't be as directly tied to filing within the first week of April, but it's more the registration is done before that time period. And it's proposed that you cannot switch who you're going to file cases for. So you say, these are my 10 for individual 1 through 10. This is the information for each case. They're going to pick 5, however many of those, 3 or 4, and let you know, okay, you can go ahead and file those. And then it'd be a 60-day filing window. And so that's kind of the main change there. They said that they would give 30 days notice if this were to be implemented before April 1st. So there is still a chance that this could happen. I think it's highly unlikely, but they've certainly pushed things through last minute in some other areas. So who knows? This is just something to be aware of. still prepare cap cases and strategy the same as you always have, but just be aware of this. It still has to go through the budget office, OMB, before it's actually an actual rule. But that's something to stay on top of. As part of that rule proposal as well, the way that the 65,000 bachelor's degree and the 20,000 additional spots open for individuals' master's degree, the way that that's allocated and counted, they're proposing a change to that. The effect of that essentially would be to increase the chances of being selected for CAP if you have a master's degree. Now, how much it's going to increase that, we're not sure if they're actually going to do it the way that they've suggested. But it should slightly increase the chances that you have to be selected if you have a U.S. master's. And when you file the H1B cap cases, you let them know which, essentially, if you want this to be considered in the U.S. master's cap as well. So those are two things to stay on top of for hopefully not this cap season, because that's a lot of things for them to put in place. But for the next cap season, that should be the case. Then the administration has kind of repeatedly, I guess, threatened or talked about changing the definition of specialty occupation, which Ting talked about before, and it relates to the wage level 1 positions as well, is potentially just saying any position that falls into the wage level 1, so entry level, is just not going to be eligible for H1Bs. That it will be challenged in court, and so it's relative. It would probably take a while before it's actually implemented, because that's a pretty fundamental change to the H1B statute. So the last two items here, essentially, there's been a lot of talk about getting rid of H4 EAD and STEM OPT. So Ting explained what STEM OPT is. So it would just be blanket, just getting rid of that additional period of time you can get if you have a STEM degree. H4 EAD, so you're eligible for an H4 if you are the spouse or child, so dependents of an H1B visa holder. H4s will still be available, but currently in 2015, they allowed H4 spouses to get EADs, or working authorization documents, if the H1B spouse is in a certain part of the green card process. And so there's a lot of people working on H4 EADs at companies, and there has been a talk over and over about just scrapping that EAD program altogether. So then you're going to have alternatives ready for people who are working at your company on EAD. So know who those people are who are on who are working there on H4 EADs, and then stay on top of that obviously, because you'll need to plan for that. That's a lot of, I guess, challenging bad news. So let's focus on kind of what we can do, what you can do to help your immigration program moving forward. Ting and I strongly believe that a lot of this, if not all of this, comes back to your internal immigration policy that you have, and actually giving the amount of time and dedicating the amount of resources to not only building this out, but using this as a working document as changes come up. And so why it's important, we've talked about various of these, so I'll run through them real quickly. But from a recruitment standpoint, it really helps to be very open about your policy, to give a candidate, show your candidate your policy, to tell them, if you're here for 180 days, we're going to kick off that green card sponsorship for you if you, meet these eligibility criteria, for example. These are the types of green card cases that, that we're willing to sponsor. So it can really help from a recruitment standpoint. We saw that figure of it's really important for 70% of foreign nationals surveyed. Just the green card policy itself is a big factor, which makes sense. From a compliance standpoint, if you really take time to lay out what types of visas and when the company is willing to launch these and start these, who pays what fees in this process, then it's obviously going to be easier for you to, so compliance and avoid discrimination are kind of together there, to provide benefits equally to all foreign nationals and avoid potential discrimination charges as well, that you're paying for all these fees for one employee but not the other. It's not laid out in your policy why you're doing that, what are the exceptions or what's different. Also, from a compliance standpoint, just taking the time to understand all the compliance needs, whether they're I-9, E-Verify, maintaining a public access file for H1Bs on site, what you have to do with recruitment that you posted for green card cases. There's a lot of compliance, and they're really ratcheting up site visits as well. How do you deal with site visits? Having a policy and thinking all of this through. You don't give all of this to your employees or your candidates, right? You give parts of it to them, but you really need to think through all of this. For workforce planning as well, what are kind of the trends? What are the timelines? understanding kind of what percentage of our workforce for these types of roles, might end up being foreign nationals, and what are we willing to sponsor and pay for. So from a budgeting standpoint, having projections, immigration is enough of an issue and makes up enough of your workforce that you really need to consider it as part of that whole process. And then your employee experience. So they're going to be dealing with recruitment, with recruiters who hopefully know about immigration. They're going to be dealing with HR. They're going to go through the onboarding process. They're going to be dealing with someone from an immigration law firm, someone from your internal team. And if you have a solid policy, your workflows are well laid out, then it's going to give that candidate or employee a much better experience, and they're probably going to feel like they're off to a really good start. They've picked a really good company to work for because there haven't been like major hiccups along the way. You understand that their green card sponsorship is a huge deal. You understand that it's important enough that you actually have this policy in place that you give them. You talk to them about it. You're willing to pay these fees, or they know what fees they're going to have to pay. It just shows that you really understand what they're going through. So from an employee experience standpoint as well, it's a big deal. So some key considerations. There is an immigration policy handout that you should all have, and it lays out various questions to consider just kind of to get that process started. And then I think pages 2 through 5 or so, or 6 even, it has like sample clauses from immigration policies that you're welcome to take a look at. Hopefully those are helpful just to give you an idea of kind of what this might look like and how it might be broken down. So key considerations, we'll pick a few that are listed on that guide. So do you want to have an employer or employee-driven program? Do you want to put a lot of the onus on the employee to nudge the manager and say, hey, when can I get my green card process started? Will you pay these fees? Will you pay fees for my dependents? Or do you want to have a very clear policy where you as the employer, you're really driving this process, you're keeping track of how long someone's been there, how good of a job they've done, and you let them know, we're ready to start this process for you now. And we've seen policies that are all over the map. A lot of companies don't even have these policies. So at least have something and then just build from there. Again, what visas do you sponsor? Is your company willing to take on that J1 trainee visas, or does it not make sense? Timelines for sponsorship. Are you going to kick off that green card the day that they start? Are you going to wait 6 months, a year, 2 years? How much do you want to use this as a competitive advantage? Try to understand, kind of do some benchmarking with your team on what are your competitors doing, because it is a big deal. Who pays for fees? Are you willing to cover the costs of the H-4 for the spouse and children of the H1B holder or not? There are some mandatory fees that have to be paid in the green card process. For example, generally one of the 3 steps the employer has to pay for, but they don't necessarily have to pay for various of the other steps. So you put that on your employee. Do you cover all of it? Again, it's a recruitment tool, but it needs to be clearly laid out. Again, you don't want to apply this differently between different people. You're really opening yourself up to a lot of problems from a discrimination standpoint there. And then just the last one, when to withdraw sponsorship. So H1B employee leaves your company. Do you notify USCIS on that day that they actually leave? Some companies want to be a little bit flexible and allow them some time before you actually notify USCIS. Is that a good idea? So you really need to think through a lot of these considerations. There's some more on the handout, and there's a lot more beyond that as well, depending how willing you are to put a lot of time and energy into this, and we highly recommend you do.
All right. Thank you, Hendrik. So we've made the case why immigration policies are important. We strongly refer you to the sample that we provided. You can even use that as the basis of immigration policy if you don't have one. I've seen recruiters give those out when they, have the discussion with the prospective employee. Just make sure that you're really all on the same page with the different stakeholders at the company. And that's really what one of the main things you can do is staff training. Make sure that everyone knows about your immigration policy. It shouldn't just be this document that you spend all this time on and then your managers don't take a look, or and it's hidden away in a filing desk somewhere. So all the relevant staff at your company should be apprised of the immigration issue. And by that, I mean executives, hiring managers, recruiters, and sponsored employees. And we'll talk about the HR department's role in a bit. But for your executives, you should really be staying on top of trends. You know H1B is an issue, so allocate resources to your HR department, to your managers, give them training, enable them to succeed with immigration. For hiring managers, one of the things that you should really do is have them look through that visa guide. It's 19 pages in all, including the cover page, and it really lays out very clearly the basics. So if they have a team of employees on any one of these visas, they know what the employee is going through and what other concerns they're dealing with. For recruiters, get familiar with the immigration policy. You're going to get a lot of these questions on timeline, on cost, and we saw in that very first slide, right? 70% of people think the green card policy is a big deal, whether to join the company or not. So getting really clear about that and making the right promises from the very beginning will go a long way in establishing that good faith from the company. And also for recruiters, take a look at the visa guide. Again, you're going to get questions about these different options. I mean, Tina and I were talking, everyone has a friend who's done this special visa. So it's good to be aware of what that visa might be and then explain why it doesn't make sense for the company, if that's the case. And for the sponsored employee, share the immigration policy. They want transparency. Connect them with immigration contacts, whether that's internally or immigration attorneys, whomever. I mean, they have a lot at stake. So, of the hundreds and perhaps thousands of employees we've worked with, I found that most are really understanding so long as they know you are taking the time to put their case as a priority. And to do that is just communicate and let them know that you've thought about these issues and here's our guidance on it. The HR department in most companies are tasked with dealing with immigration. And we've seen that this is what's going on with the H1Bs is really just the tip of the iceberg. So to the extent that we can, we strongly advise companies actually provide HRs with the support that they need. I mean, they still have to balance everything else they need to do on top of immigration. And so here are some, take-home suggestions that you can really do today. So one thing is use a cloud-based account for regulatory compliance. A lot of jargon, but what we really mean is all this stuff that you're supposed to keep track of, I-9s, pass for LCAs, scan them, put them up on the cloud. There's no requirement anymore that you have to keep paper files. And it's much easier to update these things when it's on the computer. And then moreover, you can decide exactly who has access to it. And that brings us to our second point. The point of kind of getting organized with all this compliance stuff is so that in case you're one of those companies that gets selected for an unannounced site visit by immigration, you are prepared. You have set up a plan and put a clear chain of command in place in case that happens. So I really want you guys to take a look at the immigration site visit guide where we actually list out, the purpose of these visits, the sort of questions you can expect, and how to answer those questions, and how to, the procedures, like who should you direct these questions to? This is something you should be doing to train your receptionist and your HR staff so that, you guys are not, caught like a deer in the headlights when that person shows up, because you are not going to get a warning. And encourage your managers and your employees to get familiar with the questions. They're not hard. These visits shouldn't be scary as long as you know what to expect. So lastly, I would say, it's very important to get outside support if necessary. So Hendrik and I, we work with a lot of companies internally to help build out the policy, build out their program to answer these questions, because we really saw this need from early stage companies compared to the larger companies. but if you are, just working with the immigration firm, try to use them as a resource. If you have questions about the job descriptions, really ask them in advance. Whatever you can do, I think there's certifications that SHRM has on immigration for HR professionals. Just learn more. And, even though everything is changing so quickly, you'll be in a much better place, and you will, enable your immigration program to become that thriving solution for retention that we talked about from the very beginning.